question. If Mr. Sage is here, it will certainly belong to him. And if there are no other questions before we run out of time at 8 o'clock, I did have one. We can put the question to whoever you wish, and they will deal with the question.
Because our name is similar to a name of another charity in the U.S. that suspects being represented in the Muslim community, we had to deal with issues of the policing community not knowing their rights, not being educated about what their existing rights are and how this legislation might affect them. We had to deal with issues of limited resources. All of these. Now, and as well, in going forward, and I guess this will sort of come to my question, is that with this legislation, in all honesty, it is going to have a disproportionate impact on certain communities. The Muslim community is one thing. So for this legislation to have some legitimacy in their eyes and some confidence for them that they're not going to be unfairly targeted, we need to know how this community is going to be involved in the policy discussion, in continuing legislative formulation, and in the law enforcement. To give you a personal example, the Muslim Lawyers Association tried to get before the House of Commons Justice Committee to make representations on Bill C-36. When we got together, we got together with a coalition of Muslim organizations. When our coalition numbered about 40 organizations in the Metro Toronto area, we couldn't get a hearing date. We were told, a lot of other people are coming. Then we accumulated about 70 organizations. We were still told, sorry, no date. We accumulated about 120 organizations before they said, okay, you can come on the last day. And we eventually represented about 140 organizations. But the struggle that we had to get there told us that, look, it's not an open and transparent process. Not everybody has a say, and not everybody say has an equal right. So I think that's sort of my question to the panel, is how can communities who will be disproportionately targeted feel to be made part of the process and their input to be seriously, not only on aspects of how to address the civil rights issues, but also in participating in the safety and security of communities.
Can I just answer quickly? And then Stanley can? I think you can participate because you will be put in preventative detention and and people from your community will be charged with terrorist offenses, and that will be called participating.
I don't think that was very helpful to you, but this bill has only today reached the third reading stage. I won't go too far with this, but basically, when I sat down, I was told that I was a very effective government apologist. So I'm also dealing with some difficulties here today as well. But to go back to your question, this bill has only reached third reading stage today, and the Senate has yet to determine what its course of hearings will be like. And I would encourage you and all the organizations that you have represented to attempt to gain as fulsome an experience in the Senate process as is possible. And I would encourage you to come up with specific concrete recommendations and strategies for addressing those matters while this bill is still involved in the legislative process. That is perhaps, that's me speaking as someone who is concerned about the democratic values and the legislative process that we have in Canada. It, I suspect, is what the government would wish as well. I'm here representing the Department of Justice from a particular perspective, but I encourage you to do that.
You don't mind me asking, will it be, do you think it will be the same struggle before the Senate as it was?
I can't tell you the answer to that, in part because the Senate did something quite unusual in this process. The Senate had a pre-study of the legislation, which means that it accepted the legislation for study prior to its introduction in the Senate. And it held hearings parallel to, and indeed in a swifter fashion than the House of Commons, in order to prepare a report that would have some influence on the legislation. And indeed, the Senate report did have an effect on the legislation as it came through the House of Commons process. But formally speaking, the process is not over, and it will be up to the Senate to determine what its own procedure will be when the matter comes up for consideration there.
Is it a matter of concern that there seems to be, when you look at the Act, a very wide ministerial discretion with regard to a great many matters? Is that something that is something we should be concerned about? I must say it worried me looking at it. It did more than worry me.
Well, I guess it really depends on the matters that you're examining. I would say that the bill contains a great many matters that are regarded as matters that require the prior consent of the Attorney General. Now that is obviously something that I think we should view as a safeguard. The prior consent of the Attorney General before a warrant can be issued or before a person can be compelled to answer questions is an important safeguard, because it means that it is not up to just any peace officer or any prosecutor to bring the matter forward. So certainly those matters, which are matters of ministerial discretion, are matters that are meant to be inserted in the legislation as a form of control. In addition, there is an annual reporting requirement that is part of the amendments that have been accepted. And this annual reporting requirement will require attorneys general, and that's not just simply the federal attorney general, but the provincial counterparts as well, solicitor generals as well, to provide information on an annual basis with respect to such matters as preventive arrest and compelled questioning. And this will have a bearing both on the parliamentary review process, which is to take place in 3 years under this legislation, as well as on the debate concerning the sunsetting of the legislation in 5 years' time. So I really think that the issue of ministerial discretion would have to be considered in the context of each individual provision.
Before I get into this ministerial discretion, I'd like to jump into the answer. I agree with Mr. Cohen that you should try to get into the Senate process as quickly as possible, but I don't see much hope for any group to change what has been cast almost in stone here. The opposition in the House of Commons couldn't get anywhere even after the amendments, and when the Senate committee made its views known with respect to amendments, these were housekeeping by and large amendments, and the annual report and sunset provisions really don't help the individual who is detained and subject to investigation. The second thing I would recommend is that you immediately make representation to the Governor and Council and the Solicitor General of Canada with respect to these lists. We didn't talk about the lists, but you're a terrorist group if you're on the list, and you're on the list if the Solicitor General puts you on the list, or the Governor and Council, that's the executive, puts you on the list at the recommendation of the Solicitor General, and if you're on the list you can't get off, you're on for 2 years, and so on and so forth, which means that you're more susceptible, and the groups that are part of that list, or the groups that are part of the identifiable people who are said to be part of the terrorist groups, and all of those who might have information are at extreme risk under this legislation. And I think you have to look to that and be prepared for it when this bill becomes an act. And I'll guarantee you that the form that we have it in now will be substantially the form that it will be in, notwithstanding what Mr. Cohen has said. With respect to the Honourable Mr. Corey's question about ministerial discretion, under the Act, the amendments to the Canada Evidence Act allow the Minister, the Attorney General, to in effect control the process not only of getting into a prosecution where there is sensitive information to be revealed, but to control the revealing of that sensitive information in a manner quite untoward and quite new to our society. The Attorney General has provided in the recommendations here in the bill for a review process. You go to the federal court, you don't go to the Superior Court. If there's a provincial or Superior Court trial where, or a provincial court trial in the Ontario Court of Justice, for example, where sensitive information is going to come out through a police officer, as I understand this process, and Mr. Cohen can correct me if I'm wrong, what happens here is that the officer has a positive obligation to notify the Attorney General, hey, I'm about to be asked to give out this information. There's certain procedural hoops that have to be taken, and that brings the matter outside of that trial into the federal court, where 15 additional judges are provided for in this act, federal court judges. Some people call it court packing. I'll leave it to you to decide what it is. A switch in time saves 9 is an old historical Washington phrase. But through the process, if the Attorney General sees that the prosecution isn't stayed, which the judge can do if there is to be a release of this information, ultimately the Attorney General can control the release of information herself. She can take her ball and go home. That information won't get out. So this secrecy is there. There's no transparency here. And while we're dealing with provisions, and Mr. Cohen said, in effect, the government is looking to Section 1 justification, and I hope the brainwashing of the public and others, and most particularly the court, isn't successful. This isn't charter-proofed. It's been scrubbed, but it's not completely clean. And prescribed by law is a phrase in Section 1 which raises the void for vagueness doctrine. Consider all of the vague provisions of this act and answer whether or not Section 1 has been complied with. But most importantly, if national security concerns are the reason for the invocation of Section 1, what proof will the government offer to a court that these are indeed realistic national concerns when Canada herself has not been directly attacked? That's a very basic question which has yet to be answered.
If I may. As usual, Morris has put a lot of balls in the air and makes it difficult to juggle. But the designation or listing issue, I think, is one that should be dealt with because it's been raised in a way that perhaps doesn't fully capture what the process is about. In the legislation, the Governor and Council may, on the recommendation of the Solicitor General, establish a list of entities. If the Governor and Council is satisfied there are reasonable grounds. This is unusual language in legislation with respect to the Governor and Council, to believe that the entity has carried out, attempted to carry out, or participated in a terrorist activity or acts on behalf of or at the direction of or in association with an entity that's referred to. So the Solicitor General must have reasonable grounds to believe that this standard has been met. Now, the process by which an individual or group gets added to this list incorporates a number of procedural safeguards. Firstly, the application, there is an application for removal, so you don't stay on the list as has been indicated here. And this includes on the basis of a material change in circumstance. Secondly, the judicial review of whether reasonable grounds existed, and if not, removal from the list can flow. Thirdly, there is access, albeit there is an in-camera aspect to this. There is access by the reviewing judge to the intelligence and other information. I know we've spoken of the shortcomings in those kinds of procedures, but it is an aspect of allowing judicial supervision. And there is also the aspect of the provision of summaries of information, which the Supreme Court of Canada in national security context in Chiarelli has accepted. Mechanisms are also included to address cases of mistaken identity and to permit the issuance of ministerial authorizations for specific activities that would otherwise be prohibited. And the list itself must be reviewed every 2 years by the Solicitor General. And of course, we are not unique in the creation of these particular lists. And part of this, as you know, has been brought into existence as a result of the international conventions and protocols to which we are signatories and have ratified. So that aspect of listing, of course, is important. I think I should let the others speak to this rather than to get into all of the issues that have been raised.
Yeah, I just wanted.
Barbara had a question.
It wasn't a question, it was a comment.
No.
In terms of Stanley's comments. The review, as I understand it under the legislation, is in the federal court of the listing. And I really think that maybe there should be a little committee struck on how to find ways to challenge the legislation in the Ontario court. I am telling you, come and watch one of these hearings in the federal court. They are so, I mean, you look at the Security Intelligence Review Committee under the same provisions of the legislation, the same process in the legislation, you have a 50-50 chance of winning. In the federal court trial division, I mean, I don't understand how a court can be less fair than an administrative tribunal, but they are so much less fair than an administrative tribunal that they're to the right of Attila the Hun. I mean, I wish I could say that it was a fair process. It's not. And when you go on the listing thing before the federal court, the judge will hear it in secret. You will never know what it is. You will never get a chance to test it, and the organization will stay listed. The reason the government has moved everything to the federal court, including in the Immigration Act, the permanent resident security cases, is because they win. Under the security provisions in the federal court, 2 people have succeeded in the entire time that the act has been in place. Everybody loses because reasonable grounds means it's possible that the evidence before the judge is true, and therefore the evidence that you accept may possibly be true, may possibly lead to the conclusion that you're a member of a terrorist organization or that the organization is terrorism. It's an illusory standard. You can never meet it. The only people that have won have been the Smiths, where the government pursued the security certificate when they didn't have evidence to support it, and the Jabala case where he had taped the CSIS officers, and the CSIS officers were found to be lying on the stand in front of federal court because the conversation was taped. So those are the only 2 cases that have ever succeeded. I mean, really, just come and watch if you want to see what happens in federal court, and that's what you're all looking forward to under this legislation.
I feel that there's not much that I can say in answer to those kinds of allegations with respect to the federal court.
Well, I think we have to
and I was
remember
going
that
to turn to you because I think that someone should be here to speak for the federal court in defense of itself. This is Canada.
we cannot forget that one of the great judges of Canada, Frank Iacobucci, was Chief Justice of the federal court. And if you think that he would ever go against his oath to rule according to law, his conscience, that would be a terrible mistake. He is an outstanding jurist and is a representative of the federal court. Perhaps that's the danger in generalizing. Of course, there are members of the court that I'm sure that do their utmost to uphold the law.
I'm not cutting up the whole federal court. I recognize there are very good judges. There are a lot of judges that are not cleared by CSIS to hear these security cases. There's only a few. And not even all the security cleared judges are judges that I think, I think they do their job. It's just there is a very restrictive interpretation of what's fair in these procedures, and once one judge makes a decision, the rest of the judges follow it. But I don't withdraw my remarks. It is not a fair hearing.
I think that one of the difficulties that we have to address eventually is the perception. And if there's a perception that the matters have been moved into the federal court without a substantial reason, then perhaps it's up to the minister to tell us, or the minister's staff to tell us why this was done, so as to avoid that perception. Perception is reality to a lot of people, and it's very important that we have and continue to have utmost confidence in our judiciary, not only Justice Iacobucci, but others who, the late Mark McGuigan, you know, Mr. Justice Linden, Mr. Justice, exactly, Mr. Justice Sexton. These are all outstanding jurists who are people of integrity.
Well,
But the perception is very important, and I think we have to address
This isn't a situation where we should pick our favorite judge. I mean, I think that that's not the point. The point is that essentially there's been a slander on a court. And the question is, which court will we slander tomorrow if we're talking about the quality of justice in Canada? The issue really has to do with whether or not the legislation that we're here to consider tonight has sufficient checks and balances and processes and safeguards that are built into it for the judiciary to be able to do an adequate job.
There's a
question
question
jump.
coming. I'm so sorry. I wonder if I could just hear that.
I haven't spoken. I have to, look, calling this a slander on the court, that's exactly the kind of mentality in these times that we cannot deal with. This is a criticism of a court from somebody who practices for it for 20 years. I've read enough cases of that court to know that the standard of judicial conduct in terms of their ability to work with the law in a way that's humanistically informed is deeply problematic. Okay? So these criticisms come from somewhere. Calling it a slander on the court is a way of cutting down on criticism at a time when, in fact, you should be sending the other signal.
Yes.
Actually, ditto, and I just wanted to make a few further comments and then a question. Just by way of further comment, I think that part of what we're seeing with the federal court also pertains to the fact that we have incredibly problematic immigration legislation. The reason we get that decision from the federal court, in addition to comments that were already made by both Laura and Craig, pertain to problems in the Immigration Act that exist. Mr. Cohen, you mentioned that, you know, many of the concerns raised here this evening
try to take a stab at it. I've sat through the hearings for the most part, or at least where the minister has appeared and where the parliamentary secretary has appeared. And the message that has been advanced in those hearings is that what is necessary are measures that are designed to prevent terrorist attacks and terrorist threats from essentially growing into terrorist activities in Canada, terrorist attacks in Canada, or indeed in other parts of the world when Canada might be used as a staging ground. The particular example that the minister gave in her speech was that basically her position was that if a terrorist gets on the plane, essentially it is too late. And I think that what we have here are some aspects of preventive legislation, which of course are unprecedented in Canada in the sense that they are being used in the context of a law enforcement investigation, but basically compelled questioning and preventive arrest are meant to be preventive measures that are designed to disrupt terrorist activity and prevent terrorist offenses from being carried out. So those particular matters, which are not addressed elsewhere in the criminal law, are matters that the government felt impelled to move on. That is the explanation that's been advanced. With respect to other matters involving financing and the like, the same kind of reasoning applies, that these fruits or these particular aspects of terrorist activity were supposed to be, let's put it another way, these particular activities were difficult to get at because of the ability of those who engage in them to obtain the funds and the resources that were necessary in order to carry out their designs, and therefore in order to bring ourselves into line with the international conventions for the suppression of terrorist financing and the like, these measures have been brought in.
Those international conventions are against international terrorism. The armed conflict in Sri Lanka, the armed conflict in Sudan, the conflict in Turkey are not international terrorism. They are armed conflict within specific states. Why is Canada stopping people in Canada from supporting their friends and family in countries where they are subjected to severe state repression? I mean, when the Sri Lankan government bombs Tamil villages and churches and schools, why can't they send money to help the orphans? Because that's where a lot of the money is going. But what is it our business to be stepping in and siding with the Sri Lankan government when it's a repressive state?
Well, I basically can't answer questions that are directed at particular circumstances. There is the provision that you have focused on dealing with armed conflict and how that particular phrase has been interpreted in international law, under conventional international law, under customary international law. Basically, it allows for a certain leeway and latitude, as you know, in relation to struggles of self-determination.
But the Americans and the British didn't give these extraordinary investigative powers to every single peace officer in the nation. And they didn't see fit to create new predicate criminal offenses as we did. And they didn't see fit to create the kind of offenses that are so broad as to cast such a broad net as to scare people who are in legitimate businesses. That's the difficulty. And so the answer has never been forthcoming from everything I've read as to why it was necessary. If you need investigative tools, then you create investigative tools. You did it, the federal government did it with respect to wiretapping and kept the judiciary in tight control. The judiciary are not in tight control under these investigative measures. The police are in control, and to some degree the executive branch of government is in control. And that's what bothers me about this particular response. Instead of pouring more millions of dollars into CSIS and other investigative agencies in order to catch terrorists. They've paraded this bill as part of the new criminal code. And the difficulty is that once it's entrenched, these temporary measures become permanent. They become accepted. We are very accepting as a nation of laws. We respect our lawmakers, we respect our courts, we respect our law enforcement officials. And we become used to this kind of law. And in 5 years, it'll stretch. It's been stretched from where it began with respect to powers of search and seizure to where it is now. And I still have difficulty in seeing the rationale for such an omnibus bill. If you say there are 2 investigative techniques that have to be tried as something new, you put them in effect and you pour money into them, you put in judicial safeguards, and that's the end of it. That isn't what this bill is.
I think perhaps it's getting to 8:30, and if we go to beyond 8:30, I think you undoubtedly have to pay extra money to the Law Society of Upper Canada. That could be used for charity, and the other thing is that Professor Stewart has arrived, and the poor soul was on a broken-down train for over 3 hours, and that explains his inability to be here with us. Yes?
I'm a civil litigator. I don't get involved much in these kind of issues.
Yes, you will.
Thank you tonight. What you said is very illuminating. I wondered why I was here, and then I remembered what happened this week. I got a call from a client who was a doctor, the team doctor for one of the Canadian sports. He tried to get on the Air Canada plane in Seoul, Korea. His extraction was Arabic, and he went through all the security measures, and he took his seat, and he was then taken off the plane and searched again and interrogated and treated very badly. And I'm now in the process as a civil litigator to determine if I have a cause of action against Air Canada for some type of racial profiling. And how have we changed? It seems as if we've gone backward incredibly in our human rights laws, and we're now starting to racially profile people. I don't want to live in a country like that. And I encourage Mr. Manning and Ms. Jackman, because I'm not going to be there, but I encourage you to raise whatever you can in the Charter of Rights to put down this legislation, because this isn't right. We don't need this in our country, and I don't want to live that way. And as I say, I'm just a simple civil litigator dealing with mostly commercial cases. Thank you, panel. It's been great.
Give me just a couple of moments. I won't keep you long at all. I just want to take this opportunity to thank the people who made this possible. They fall into 2 groups. Firstly, the organizers, and secondly, the wonderful panel that you've heard tonight. This program originated in the Constitutional and Civil Liberties section of the Ontario Bar Association. Maria Duckworth and Mary O'Donoghue supported and guided and encouraged me through the entire process, and I owe a great deal to both of them, as do we all. They were fundamental to creating this program. Paul Truster of the Law Society and Kelly Gorman of the Ontario Bar Association came forward to make this a joint presentation of both bodies. Kimberly Weaver of the Ontario Bar Association assisted us throughout the entire process, and I thank all of them. I should add as well that you should keep an eye open for Law Society and Bar Association programs in the future that will deal in greater detail with the fallout of this legislation. In fact, I'm told that there is a program next week, next Tuesday, on the impact of this legislation on charities. For more details, get in touch with the Ontario Bar Association and the Law Society. Most importantly, let me thank Justice Corey for being a wonderful moderator and for all of the speakers and their terrific presentations that have enlightened and engaged us throughout the evening. Thank you so much for being here, and thank you, audience, for your participation and your great patience. Thank you very much. Professor Don Stewart has been a professor of law at Queen's University in Kingston since 1975. I'm going to start again. Professor Stewart has been a professor of law at Queen's University in Kingston since 1975 and editor-in-chief of the Criminal Reports since 1982. He has published extensively on many aspects of the criminal justice system. His recent publications include Canadian Criminal Law, a treatise, and Charter Justice in the Canadian Criminal Law. He teaches the following subjects: criminal law, criminal procedure, evidence, and his recent professional achievements include being editor-in-chief of the Criminal Reports, consultant to the Department of Justice on criminal law issues, 2000 distinguished visitor to the Faculty of Law, University of Manitoba, advisor to National Judicial Institute on Criminal Law e-letter. And in 1998, he received the Canadian Association of Law Teachers Award for Academic Excellence. Please welcome Professor Stewart.
Thank you very much, Deborah. I'm very sorry that I missed the panel discussion because of the train troubles, which delayed me for 3 hours on the train tracks, feeling very frustrated. I blame the Department of Justice for that. When we all saw the planes exploding in the Trade Center and the towers falling, and we saw the carnage, we were always affected. We were all affected, and we always will be affected. We expected our government to be proactive, and they were. And I think it's very easy to support the government's measures for better airport security, medicine to counteract anthrax, and indeed many more resources for anti-terrorist police, CSIS personnel, and even for military assistance to that rather uncomfortable war in Afghanistan. Those planning or committing acts of violent terrorism should be arrested, should be prosecuted, and should be severely punished. But that's not what the issue is before us when we look at Bill C-36. The question is whether this juggernaut of dragnet powers was necessary. It'll be my position that it was not necessary, and almost all of it should have been withdrawn. When the state turns to the power to punish under the criminal law, there's a high standard of justification, even in extraordinary times. Basic principles of criminal justice require that there be a meaningful act requirement, meaningful fault requirement. There must be a responsibility based on fair labeling, and punishment must be proportionate to the accused actions. As many have said since Bill C-36 was tabled, the definition in the bill is far too wide. Government tinkering has not made these concerns go away. In my view, the breadth of definition of terrorist activities, combined with the pernicious way that the crimes in the bill have been declared, cut across basic fundamental principles and should not be enacted. There are more than sufficient offenses well suited to the prosecution of violent acts of terrorism, planning for terrorism, and acts aimed to aid others to commit terrorism. As for police powers, we had more than adequate investigative powers available both for the police and for CSIS. We needed and need better intelligence and more evidence. We did not need these new laws. Bill C-36 will put in place into our permanent legislation huge and complex new legal powers, including a web of dragnet police authority, such as detention without charge, without parallel in Canadian history. We have a concept of detention on reasonable suspicion, but that's only a stop and frisk search power. It doesn't allow detention for questioning. This one is a misnomer. It talks about a reconnaissance with conditions. Could have been more forthright. This is a power to detain without charge. There's another power, of course, of compelled testimony before a judge. Also, the major characteristics to me of this bill are a huge grab of unfettered ministerial powers. I think of the power of the Minister of Defense to authorize electronic surveillance without the need to go before a justice.
I think of the power of the Minister of Justice to issue a fiat to ensure that sensitive information is kept secret. I think of the power of the government to promulgate a list of terrorist entities. Yes, there's a review after the event, but not at the time that the list is assembled. This massive new state power is unnecessary. It will not make Canadians safer, and indeed it will more likely endanger the freedoms of the more vulnerable. I think particularly of minority groups, immigrants, and especially refugees. That is the view of a coalition of more than 140 Muslim Canadian organizations representing a sizable proportion of Canada's 6,000 Muslims. They report their numbers have already been targeted since September the 11th. The issue of racial profiling is a very complicated one, but thus far protections against discrimination in Section 15 have not been of assistance. And this is the last thing we need to do, given that huge problem which already exists, to be creating ever and overly wide powers. Irwin Cotler, the Liberal backbencher, should take a considerable amount of credit for getting the government to soften the bill. So too, a panelist on tonight's program, Stan Cohen, I know well. I'm sure that the bill was worse before he and his department worked hard on it. Now that doesn't make, however, the bill right. Now, Irwin Cotler suggests that criminal lawyers like myself and others should think out of the box. He says we shouldn't think about the domestic due process model. We should be talking about international criminal justice counteracting a transnational and existential threat. This is human security legislation, he says. Now, I think we can all agree readily that of course Canada should support the United Nations. Of course Canada should support worldwide consensus on moves against terrorists. Of course we should do those sort of things, but that's not what we're talking about. The box that I'm talking about tonight is a Canadian prison or police cell. That's what we're talking about. We're talking about the application of powers to people living in Canada. If it's not a police cell, it's a home in Canada when there's a knock on the door that says, we have information that you're a suspected terrorist. The threats to these freedoms are not existential. They're very, very real. And I'm certainly, when we get involved in international comity, I'm quite sure that most Canadians, and certainly not the Supreme Court of Canada, would support George Bush's order setting up secret military tribunals with powers to execute. So there's some limits to international cooperation from a Canada as proud of our traditions as us. Now, I don't think we should be beguiled by promises of phony sunset clauses and parliamentary review. The amendments that Parliament voted on, presumably this afternoon, have only slightly improved this bill. Irwin Cotler only got 6 of the 10 things he wanted to achieve. It's only marginally changed. As I've said, the minister can still list terrorist entities without advance notice. There's now some limiting judicial review of some of the powers, but not many. Now, what are these sunset powers? They're in respect of these 2 major new powers of detention without charge, compelled testing, and investigative hearings. As opposition ministers, opposition MPs have pointed out, this is not a true sunset clause. A sunset clause is one that expires and has to be renewed by Parliament starting with reading number 1. This is a sunset clause which just can be, those powers can be continued on a government vote. That's not satisfactory at all. Now, in respect of those 2 particular powers, what's so wrong with them? What's wrong with detention without charge? Well, what's wrong with it is, yes, it's only 72 hours. Yes, there are other countries that have used bigger powers of detention without charge. But this is groundbreaking and part of our permanent law, unless it's sunset. From my background in South Africa, I know that when a repressive regime start enacting powers to detain on suspicion without charge, there's a tendency to escalate. They'll be bigger next time, 2 years down the line. Hopefully they won't be needed, and the government will realize that they shouldn't have been enacted in the first place. On the issue of compelling testimony before judges, I really have a great deal of difficulty with that provision. There's no record of success of judicial compulsion of witnesses to testify. Just think of the domestic assault situation. How many times has a person who does not want to testify testified because the judge has said, answer the question? And so I'm not sure what it would achieve. Now, it seems to be based on setting up some sort of new intelligence gathering mechanism. Now, the setup, that 72 hours of detention, would allow interrogation in custody. And, well, actually, it would sort of be based on the notion of you can go at them before a judge and you can get access to it. And it really is a setup which encourages jailhouse informants. What a time. We're doing that at the time we've just had Justice Corey's Sofno inquiry report, which talks about a wrongful conviction based on that type of testimony. But my major problem with the investigative hearing is if I'm a detective or a CSIS official, I don't think I'd ever use it. If I've got reasonable grounds to believe that there's somebody who's a terrorist, I'd arrest them. I'd read them their rights. I'd afford them access to counsel under 10b, and then I would interrogate them with the full power of coercive methods authorized by OICO, Supreme Court of Canada's ruling, and that would have the advantage the evidence would be used. I don't see the point. Now, in terms of annual review, again, we shouldn't be beguiled. This is no annual review. As I read Section 8331, it talks about statistical reports. Now, Parliament has been very bad at reviewing itself. I'll give you as an example electronic surveillance provisions. We were told in 1974, don't worry, they're going to be reviewed. The annual report's about a page long. 184 authorizations given, 183 granted, asked for, 183 granted. We've now already, before this bill or the anti-gang bill, had the widest electronic surveillance powers in the Western world. We certainly didn't need, and we certainly haven't checked electronic surveillance through annual reviews. Now, I want to make a point which might be different from some of the other speakers. I think there's a real systemic problem, speaking away from this terrorism bill. The systemic problem is the law and order frenzy of federal politicians to ever toughen up the criminal law, ever make it more complicated. This has been going on for 20 years or more. And we've had successive complex legislation responding to Supreme Court rulings, victims groups, police, prosecutors. What seems to be happening in these sort of bills is you ask the chief investigator, what powers would you like in your wildest dreams? And he says this, and you give them to him. There's absolutely no balance in the law enforcement and law reform business and the creation of new laws. And it's not, when academics like myself talk about this, we're always tarred as, well, you're a destructive thinker. You do nothing but criticize. It's not true in the case of criminal law scholars in Canada. For years, we've been producing constructive and detailed books, articles about the need to simplify criminal law, make it less complex, make it more balanced. This has fallen completely on deaf ears. It's not just academics. Think of the example of self-defense. There would be judges all around this space. Go to Old City Hall, go to University Avenue Courthouse, would be completely non-contentious that the law of self-defense is a complete mess. There have been calls for Parliament to do something about that since 1975. That's 25 years. There have been calls from Justice Michael Moldova on the Ontario Court of Appeal, Chief Justice Lemaire, the Ratushny report. There's time to draft all these omnibus bills which come out of the Law Uniformity Conference, which is populated by 95% of the people of prosecutors. But not one time, not one moment, apparently, to have half a page to simplify the law of self-defense. Now, in the media, there's often strong criticism of the activism of the Supreme Court. My point here is there needs to be strong criticism of the activism of Parliament. And I hope that something positive will come out of the opposition to this bill, which is going through like a freight train. There's skepticism, I hope, of the process that was done in this particular case to give this bill. There should be skepticism of the completely tortuous legalistic sections and exceptions. I don't think there'd be a lawyer in the country, except those who drafted it, who've read it all, will really understand it. So I think that nothing is going to change unless we become more skeptic about that. I think there's time to have a new Minister of Justice with a better sense of balance. I make this criticism against Anne McClellan. I'd also make it against Alan Rock. I think rather of politicians like Warren Ormond in 1976, Solicitor General of Canada. He abolished the death penalty when so many people were in favor of it. We need leadership. We need better balance. The portfolio of the Attorney General of Canada is a very important one. We need some moderation in the future. Many of us have got used to saying in the debates on Bill 7C36, well, it's probably charter-proof. Well, there was a bit of hope last week when the Supreme Court in the case called Mentuk handed down a decision which the Supreme Court unanimously declared that the press must be allowed access to report police methods, in this case an elaborate sting operation. The court said quite simply, Canada is not a police state. I would suggest to you that very many parts of this bill would move us in that direction, and perhaps this Supreme Court won't be so easy to persuade that it's charter-proof. I think particularly of sections where we're often not talking about, under what's now going to be called the Security of Information Act. That is a complete misnomer. It's better called, as it used to be called, the Official Secrets Act. We're talking about secret trials and secrecy. I have a few minutes left, and I'll take them up in this way. I don't think we should also be beguiled by ministers of justice who say, this is targeted only against terrorists. This is not targeted against minority groups. This is narrowly targeted. It isn't. And the experience that we have from the anti-gang legislation in brief would be, this was legislation that Alan Rock invented in a hurry. One day he said, I don't think criminal laws are going to help that particular violent problem in Quebec. On the eve of an election, the Quebec municipal authorities said, do something. He came back, he did it. Every parliamentarian voted for a quick bill targeted against the Hells Angels and the Rock Machine. We were told it was narrowly targeted. The actual experience with that bill has been catastrophic in my view. There was nothing less than a fiasco in Manitoba when we set up a security court to publish what were basically street-level Aboriginal gang members called the Manitoba Warriors. They all served much more time in custody than they should have. We spent millions of dollars building a special courthouse. There was no trial. All the gangsterism charges were withdrawn. Did we pause? No. On the eve of another election, we will go into another round. And this was interesting because I was called to testify in the House of Commons in an evening in a secret session, absolutely secret. So I got up and spoke about the Manitoba Warriors trial and the fact that I knew all about the court system and so on. I expected it and so on. I've done a lot of work on it. Some of the MPs seemed to be a little troubled by that experience. Nobody did anything about it, and there's no public record of that because it was secret. It was a security issue. We're going to hear more of that. Critics are secret. In that bill, of course, there was a provision snuck in also to deal with the unconscionable ministerial power to designate police officers to break the law. It's not just the Solicitor General. They can designate police officers who can designate other police officers to break the law. I can't imagine a provision other than the ones in Bill C-36 more inimical to the rule of law. Just briefly, I think that the other speakers in the panel tonight, which I unfortunately, as I indicated, must have missed, definitely missed, sitting on the train frustratedly. The definition of terrorism. I see that there was no reason for the government not to withdraw Clause E, dealing with intent to cause serious interference with serious disruption. It would not have significantly weakened the bill, and their attempt to make protests just to cover any form of protest is not going to work. At one level, any form of terrorism is a protest. The difference between freedom fighters and terrorists, especially with the example of Nelson Mandela, and I've been criticized for using him as an example. I was a law teacher in South Africa at the time when he was arrested. He was arrested for a violent act. He spent 27 years in jail. He made a speech at the end of it just before he was sentenced. Got anything to say? He spoke for 4 hours with no notes about a vision of a nonviolent South Africa. I was a law professor. I never got to hear it because he was banned and it was in secret. Now he's a hero. Good. I worry about any sort of notion that we're going down that direction in Canada. Now, the last thing, a couple of things left. It's not just the definition that E is too wide. It's particularly this branding of groups by the Solicitor General on a recommendation, putting them on a list of terrorist entities. This is a determination by government officials in private and without public debate, based on just reasonable grounds, not proof in a court of law. Yes, there are provisions to review now. Now, what do you mean by review? If I'm an Arab Canadian and I'm targeted, put on a terrorist group, an Afghani refugee group or something, I've been sending money, I'm targeted, I might have my assets frozen. Where's the wherewithal for me to challenge this designation? Of course, if you designated a terrorist, either by the generic definition or by being put on the list, that doesn't mean that you will be charged with an offense, but some of those other powers might be used against you. And I have two things I'd like to end up with. Some people, I don't think we've concentrated enough on the double speak in the bill. The minister says we have narrowly targeted new offenses like knowingly participate or contribute to terrorism. And she gives us an example, recruiting somebody for a terrorist group. Who could be against that? It makes such a lot of sense. Well, except when you start to read the bill. And throughout this bill, the devil is in the detail. It's not in the rhetoric. It's in what we've enacted. We read that knowingly, you don't have to prove that you knew about the specific nature of the group's activities. So if you're sending money to an Afghan group, if you don't happen to know whether half of them are Taliban or not, it doesn't matter, because you're still going to be held to have been knowingly. That's not a mens rea requirement which I'm familiar with. In terms of an act, it says you have to contribute or participate with a terrorist group. Well, one of the sections defines that as low as remaining in any country in association with a terrorist group. That's section D. Now that establishes guilt by association wherever you are in the world and whatever you're doing. And that's a terrible provision. It should have been changed. It hasn't. So even if these new provisions are charter-proof, the issue to me is that this legislation would not make us safer, and it was not necessary, either in terms of its definition or of its police powers. Finally, I want to conclude with a personal note about South Africa. I had done this before, and the National Post accused me of a false analogy, South Africa and apartheid. I am very proud to be a Canadian, but I did arrive here in 1970, just at the time the War Measures Act was declared. And we do know that a lot of innocent people were arrested at that emergency time. We do know that Parliament thought about that experience in hindsight and put in place a carefully drafted Emergency Act of 1988. That act had a whole series of mechanisms dealing with those wrongfully targeted. None of that care characterizes this act. We had time for a zillion provisions of police powers, none about wrongfully targeted people. There's no balance in Bill C-36. So in my view then, it's an unfortunate day that we're pushing this bill through Parliament. And in conclusion, in my judgment, it will confer, by and large, permanent, unnecessary, dragnet, and dangerous state powers. There's a serious risk that political dissenters still, and innocent vulnerable groups, can be investigated, detained, interrogated, and prosecuted with broad powers, broad offences, which cut across normal Canadian criminal law protections. The South African experience in oppressive regimes elsewhere warns against the risk of escalating oppression. Bill C-36 should not have been passed. Thank you.